אני פותח את הישיבה
I hereby
ה-20
open the 20th session of this trial.
בית המשפט נותן החלטה
The
מספר
court
11.
will now read decision number 11.
היועץ המשפטי
The Attorney General
מבקש
requests
להגיש כראיות
to submit in evidence
תצהירים
affidavits
ורשימות
and
של הרטל
announcements made by Hettel, Huppenkorten
ופונטדן
and von Tadden
על עניינים הנוגעים לנשוא משפט זה.
on subjects relating to the trial before this court.
מבין אלה
The first two
אנשי SS
were SS men
והשלישי היה
and the third
היה
was the
מטפל
person
היה המטפל בענייני היהודים
dealing with Jewish
במשרד
matters
החוץ הגרמני.
in the German Foreign Office.
הבקשה מבוססת על
The
סעיף
request is
15
based on paragraph 15
לעשיית דין
to
בנאצים
the law
ובעוזריהם,
against Nazis and their collaborators of 1950.
על מהות המסמכים הללו,
The contents of these documents
מה שאמרנו
לא שמעו
בהחלטתנו
באנגלית לגמרי, הם רמזו
מספר
לי
7
מלמעלה.
לגבי הדוחות
As far as the reports are
של
concerned, those made by Vislitseni,
להבדל חשוב אחד.
and with one important
שלושת
difference.
האנשים הנ"ל
The
עודם
three
בחיים.
people are still alive.
אחד מהם גר כיום
One of them lives in Austria at the moment, and the other two in Western Germany.
הסניגור מתנגד להגשת
The
המסמכים.
defense opposes the acceptance of these documents
את שלושת העדים
and maintains that the three witnesses be brought to court to be questioned before the court
יהיה לחקור
so that they may be cross-examined by the defense.
אנו סבורים
We
שיש
believe
לקבל מסמכים אלה
that
כראיות
these affidavits must be accepted in evidence
על פי סמכותנו לפי סעיף
according to the authority granted to this court by paragraph
וזאת מן
15
הטעמים הכלליים
and on the general reasons mentioned in our decision number 7.
אך עם זאת יש לאפשר לסניגור
At the same time, the defense should be enabled to examine the witnesses, whether before this court or in any other way,
שיפורט להלן.
as will be explained later. This privilege
של חקירת עד
of
חי
cross-examining a living witness by the party
נגדו
against whom
מבקשים להגיש את
the affidavits
הצהרתו
are asked to be submitted is a basic privilege and right,
וחשיבותה
and the importance of this privilege
עולה גם
is
מן
also
שחשיבותה עולה גם
the
מן
importance
הסעיף
of which is
16
also evident from paragraph 16 of the rule of evidence
הדן בהגשת עדויות
dealing with the submission of documents
במשפט
drawn
פלילי המתקיים
abroad
בארץ.
regarding a criminal matter which is being conducted in the country. We do not say that paragraph 15 deprives the other party of this right regarding these affidavits. Of course, the appearance of these three witnesses in this court depends
בפני בית משפט זה ביכולתם
on the ability and the willingness of these witnesses to come forward, to come to Israel and to
תלויה גם בכך
give their testimony in this court.
אשרת כניסה
Also,
למדינת
if they are granted
ישראל.
an entry visa to Israel.
לא מצאנו
We did not find
סמכותו של בית
it is within the
המשפט
authority of this court
להורות לשלטונות
to
המבצעים
give orders to the executive
להבטיח את
power
שלומם של
to
העדים
ensure the safety of the witnesses
והיכנסם
on their entry into the country. If the authorities consider that they cannot do so, the witness is also not immune from arrest because he may be charged on a crime, an offense against the law in Israel, on his way to the courtroom in Israel. See Freston, 11 Queen's Bench Division, page 545. The granting of an entry permit or the refusal to give such a permit because of a suspicion of the person having committed a crime is at the decision of the executive powers. According to the announcement made by the Attorney General in this court, each request for an entry permit will be decided upon, a request for a witness will be decided upon on its merits by the suitable authorities. As a matter of principle, the appearance of a witness before the court is to be preferred. But a witness who will refuse or is unable to appear may be questioned by a representative of the accused and a representative of the Attorney General before a court in his domicile, according to the agreement for legal aid and assistance, the existing agreements between the State of Israel and the countries wherein the witnesses now reside. We are ready to permit, and the Attorney General consented, that the said witnesses be cross-examined before the foreign court, if by way of interrogatories or by verbal interrogation by the representatives of both parties, or using both means of interrogation. This decision will apply also to witnesses the defense may ask to bring forward as defense witnesses, and with the necessary changes according to the matter which will be brought before the court. We expect that all the necessary clarifications regarding this matter, and when necessary, the preparation of the necessary papers to be forwarded abroad will be made as early as possible, and in any case, let it be clear that if evidence is taken abroad, the protocols, the minutes, must be in the hands of this court in due time when the evidence is completed before our court. One moment, Mr. Hausner. Instructions to the interpreter to prepare a German translation of this decision to be submitted to the court during the day. an official translation for Dr. Servatius of the decision just announced.
אתה תוכל לקבל את זה מן הקצרנית, כן? אחרי שההדפסה, ותגיש לנו את זה, מפני שפה אנחנו היינו רוצים שדוקטור סרבטיוס יקבל תרגום מדויק במיוחד.
Is interested that Dr. Servatius gets a correct translation of this decision and asks the interpreter to have a translation ready during the day.
היינו רוצים לקבל מושג, מר האוזנר, כמה זמן
Mr. Hausner, how long may it take you to verify the question of the granting or refusal of an entry permit after Dr. Servatius will inform you whom he wishes to have in the country?
I shall try to limit this to 7 or 10 days as far as possible. May I refer to the decision of the court of yesterday. I would like to finish this present matter. Presiding Judge, this is a matter of 7 or 10 days. Let us assume that there is a witness who does not get an entry visa. Could you, within an additional week or so, if you agree upon a form of questionnaire, would you be able to prepare the questionnaire? Mr. Hausner, there will be no difficulty on our side.
Dr. Servatius,
what is your view of this? Dr. Servatius rises.
Ich würde vorschlagen, dass der Antrag an die deutschen Behörden für die Vernehmung bereits sofort vorbereitet wird. Sollte der Zeuge eine Einreise bekommen, ist es ja sehr einfach, diese Vernehmung vor dem deutschen Gericht abzusagen.
I would suggest that the application to the German authorities should be submitted immediately, and if the witness then receives his entry visa, does not receive his entry visa, it will be easy to arrange for him to appear before a German court. The presiding judge. But we should like to know, in general terms, how both sides propose to act. If it is a matter of questionnaires, then both sides will have to prepare questions. As far as this depends upon the court itself, there will be no delay. This I can promise you. Everything will be done speedily. But perhaps the time has come for you to prepare a list of questions, or if you prefer some other course of action, verbal investigation, then the questions need not be drafted. I think we shall have to speak again about the way in which this will be carried through. Mr. Hausner, certainly. I think the counsel for the defense has the right to say whether he prefers questionnaire or some other method. Presiding judge, you too may wish to say which you prefer. Mr. Hausner, this can be discussed either here in court or in the office or in some other way. The presiding judge, perhaps both sides would first discuss the matter together. From the point of view of the timetable of the court, we prefer that this should come about as quickly as possible. Mr. Hausner, we shall certainly do so. Judge Halevi, Dr. Servatius' reference to the submission of application abroad, Mr. Hausner replies to Judge Halevi, no, Dr. Servatius suggested that if we wish to make applications, we should submit them as far as possible, as soon as possible, to the German or the Austrian authorities. Whether there is no standard form of application, it has to be decided whether it is in the form of questions, questionnaire, and so on. Dr. Servatius has the full right to state from his point of view which he prefers. the presiding judge. The application comes from this court, of course, and is transmitted through the Israel Foreign Ministry, and then abroad goes through certain procedures. We shall act in this case as in all other cases of this kind. Mr. Hausner, I would like to announce to the court how we see the timetable. This may be of help to the court and to the counsel for the defense. From the point of view of time, we suggest the submission. We suggest a period of 2 months for the submission of our material. In other words, we hope to complete our proof by the end of the month of June. The date of the 15th of June would be the termination of certain stages to which we would have to pass. We have managed so far to keep to the timetable which we set for ourselves. In fact, we are even half a day ahead of our timetable. The presiding judge, this isn't enough. Mr. Hausner, we shall do whatever we can, and I hope the court will understand the difficulties which face us. We have to prove the detail of all the counts in the indictment and bring evidence with regard to matters which took place over a period of 12 years, and not only in one place but in a whole series of places. We cannot do justice to our own case unless we are given time to do this. We cannot strangle our own case. In these 2 months, we have taken into account the minimal reading out of extracts from the documents, and we shall follow the request of the court and cut down the reading out of extracts to the minimum. The difference between reading out some of the extracts and not reading them out at all would be no more than 4 or 5 sessions of the court, and this is not much in a period of 2 months. We are afraid, however, that if we do not read certain extracts, even isolated extracts, the significance of some of the evidence which will be given here in court in person will not be sufficiently appreciated. Presiding Judge, the Attorney General was not here when we spoke of this matter. I'm sure you read what we said, but this was very carefully weighed by the judges before the statement was made in court. We have left you an opening, although a narrow one, and with regard to the understanding of evidence given in court by witness, this, if you think that the witness cannot be adequately understood without reference to documents, and I don't suppose there will be many such cases, you can certainly refer to this document at the time that the witness is giving evidence. This is customary and can be done here in this court as well.
Judge Halevi, the President of Court stressed it yesterday that the time is even more lengthened by the need to interpret to court. At least as far as quoting is necessary, this should be done in Hebrew, and that cuts the time in half. Hausner, we shall do so as far as possible. Whenever the document is not in the Hebrew, we shall read it in Hebrew to the court. Of course, we shall abide by the decision of the court. I only wish to explain the framework of the proceeding we had in mind. The President of the Court, it is clear that we want everything to be plain and understood by the court. We also said something about bringing the documents to the attention of the public. Hausner, we do not have the necessary staff. If we cannot do so, we shall not do so. This is not the reason bringing us to request the quoting of passages. The way we bring those passages to the knowledge of the public is by reading them out in court. President of Court, we are not here to guide you how to bring the documents to the knowledge of the public, and this does not interest the court. Find your own way how to do it. Judge Rave, we can read during 2 or 3 days much more than you can quote in court. Hausner, we shall find a way to abide by the decision and yet to draw attention of the court to all the necessary passages. I submit now a declaration made by Wilhelm Hettel, exhibit number 7. This is from the ING, volume 31. Pages 85 to page 87. I submit 3 copies. The court, this is T157. Dr. Hettel describes himself as the head of Department 6 of the Security Office of the Reich, says in his affidavit that according to his knowledge, Eichmann was charged to catch Jews of all European countries and bring them to Germany. He says that Eichmann, President of Court, I want you to follow the instructions of the court. The contents of the document in short. Prosecution, I'm through. Eichmann told him, he says, that according to his knowledge, 4 million Jews were exterminated in the concentration camps, and others were killed by the Einsatzgruppen, by the special operation groups. President of Court, I thought that here you would put the thing this way. This affidavit relates to the activities of Eichmann in his office, number 4, the number of the Jews killed. That is all that was necessary. I apologize for putting the things this way, but all you had to do was say, I call the attention of the court to paragraphs beginning with the words President of Court, we shall have a certain degree of flexibility, but this is what the court meant. Hausner, I submit now document 334 TS 2615, repeating the contents regarding Eichmann's duties and the number of Jews exterminated, the same figures as appear in the previous document. This is T 158, Exhibit 158. I also submit the affidavit of Walter Kuppenhoffen, our number 874. This was also in the IMT, Volume 2, pages 315, 323, and this is known as Affidavit Gestapo number 39. In this affidavit, Walter Huppencotton, himself an officer of Department Number 4, about the position of the accused and his being subordinate only to the head of the office. This is T159. I submit the two affidavits signed by von Taden, 1984, our number 984, also mentioned in the accused's statement. I submitted the photostatic copy in addition to the printed copies. The photostat copy is Hettel's, says the President of Court. 984 has already been submitted. President, not yet. Hausner, the certification is the Nuremberg trials. This is a document by Hoffman, was put into the hands of the accused. Von Taden maintains that he did not know of the activities in Auschwitz and pressed Eichmann to tell him the truth. President of Court, Huppencotton, 1 or 2 affidavits? Reply 1. The court, now we have the affidavit made by von Taden, and this is exhibit number 160. In this transport were to come uphill. There was a group of SS men, and we came up to them. And one of the SS men spoke to us.
What did he say?
I wish to say it in German.
Do you remember the words in German?
I remember the words,
then
and I
please
wish
state
to
them.
repeat them in German.
Sie bauen hier ein Lager. Eine Losefeld im Konzentrationslager.
I remember them saying, you are building a camp here. I cannot remember if he said concentration camp, but he said a camp, and that the guard is SS men. He pointed at the place and said, there will be a machine gun post here. The place will be surrounded by barbed wire, and up to tomorrow afternoon you must put up 2 huts. There is no water. The water carries disease. If you want water, you must search for it and dig a well, but from the top of the hill, from the summit, for years I repeated these words so often that I shall never forget them.
Always the same 5 people?
Always the 5. We got hold of a small wagon and a little, for money of course, and there was a Pole who drove us eastwards to Moldova, and the middle, between Moldova and Lublin, There was a place I can't remember the name of the place, but all of a sudden we saw SS men,
2 SS soldiers.
We jumped off the wagon. We were ordered, get off. I again wish to speak German. Get off the wagon. Do you have any money? We handed over the money. Who has more money? One of us. He had some more money. They searched him and found more money. 10 zlotys. And they ordered him to take off his clothes, all of us, to take our clothes off. And each one of us had to lie down on the earth. And for 15 minutes they continued beating us, changing the beaters, and laughing all the time. Then they ordered us to stand on our knees and sing Hebrew songs. We sang Hatikva. Then we were ordered to crawl through a concrete pipe on the road. We did this, and when we were...
Was this a closed pipe?
A concrete pipe on the road, and then we crawled back. They left us. I have my office.
You continued to treat just Jewish patients. Do you remember the name of Eichmann? Do you remember the name?
I remember.
When did you first come across this name?
In Nisko camp.
Only in Nisko. Did you see him there?
In the afternoon on the hill, I saw him.
You told us about someone who made a speech, in which you gave us extracts in German. Was that Eichmann?
This was Eichmann. The people around me who already had contact with Eichmann on the train or before that told me
this. From the men who were already there?
Yes, they told me this was Eichmann.
Could you recognize him today?
Recognize him today? No, on no condition.
Did you see the man who they told you was Eichmann again at all?
No, I never saw.